Minister, I note in your speech, before I get into the body of the bill provides that there will be no change to the civil service status of existing Garda civilian staff until an order is made by the Minister, and the making of such an order is subject to engagement with any trade union or staff association concerned and consideration of any representations made by them. You go on to say, I want to stress that the commencement of the legislation will have no automatic effect on the current position of existing civilian staff. As I have said, the bill requires there to be consultations with the recognised trade unions concerned prior to the making of a ministerial order, which will have the effect of designating such civilian staff as Garda staff. Minister, those words are not doing anything to give comfort for the 3,200 members of the Forces Trade Union who are going to be affected by this bill. Now, my understanding is that the Minister has met with the GRA, whose members are affected by this bill, but has not met with Forsa. So, if you want to get any cooperation from the Labour Party in terms of this bill, that's going to have to be sorted out, and sorted out quickly, because references like this in speeches like this don't give any comfort to those who want to engage constructively and wants to be able to bring their members on a process where they can engage positively with the changes that you are proposing. It's not a small change. It's quite significant potentially, and they need to know that their terms and conditions are going to be protected. Now, without such engagement, from the very off, that good faith is being lost. And when Minister engages with the GRA but doesn't engage with the representatives of the 3,200 other workers, well then clearly there's a problem. So Minister, I would impress on you, if you hear nothing else from my contribution, I want you to hear that the Labour Party will not be cooperating with the passage of this bill until we are satisfied that you and your department have met on an even hand with all staff associations and trade unions who will be affected by these changes. It is important to identify the core changes from existing structures which this bill proposes, Minister, and as I see it, they include additional powers and functions for the Garda Commissioner, a new non-executive board of An Garda Síochána to hold the Garda Commissioner and Senior An Garda Síochána management accountable, a new Policing and Community Safety Authority in place of the Policing Authority and Garda Síochána Inspectorate, the transfer of many current Policing Authority functions to either Garda Commissioner, the Board or the Minister. We have no objection at all to legislative reforms that would empower the Garda Commissioner to lead his service as a true Chief Executive. One concern is with the downgrading of the Policing Authority and with the new lines of accountability. My party called for decades for an external Garda oversight agency. We were determined to break the secretive and damaging relationship between that force and the Department of Justice. This relationship, as my colleague Sean Sherlock has pointed out, was vividly demonstrated in the Disclosure Tribunal report by the flurry of phone calls at senior level between the Phoenix Park and St Stephen's Green at times of crisis, calls which no one could later remember making or receiving, and whose content was also forgotten as soon as the line went dead. My party has been and remains determined to secure effective Garda accountability and oversight to an independent external body. We achieved most of what we wanted when the Policing Authority was finally established, and that body, under its chairs, Josephine Feely and Bob Collins, lived up to most of our expectations. That is why we are concerned to see recommendations that would divest the Policing Authority of its functions as an external body, securing oversight, and replace it instead with a new Board of Management. A Garda Management Board may well become ingrained with a Garda policing mentality. And if you have learned anything over the years, it is that the Garda Síochána need much less, not more, of an in-house policing mentality. Gardaí need to be required to demonstrate fully and in public that they live up to the same basic standards of fairness, decency and common sense that bind the rest of us. Or as Judge Charlton put it on page 294 of his report, central to those issues is a mentality problem. Where a problem occurs, strongly self-identifying organisations can have a self-protective tendency. That, regrettably, also describes An Garda Síochána. It is beyond a pity that it took independent inquiries to identify obvious problems with what Maurice McCabe was reporting. This bill is seeking perhaps to distinguish between internal governance and external oversight. Our concerns about the new architecture with a new Garda board revolve around the removal of functions from the policing authority in relation to the policing priorities, policing plan and Garda strategy statement, the removal of policing authority involvement in appointments, and the new multiple lines of accountability for the Garda Commissioner. There have been very many expressions of concern that these structural changes will cause confusion for the Garda Commissioner by rendering him accountable to multiple bodies with potentially overlapping remits. What is the explanation for this something for everybody in the audience approach, whereby the board will have responsibility for the strategic plan, annual service plan, capital plan, annual report and the governance framework? The authority will have responsibility for determining policing priorities, and the Minister will have responsibility for security priorities and performance targets. The Garda Síochána do need better structures of management, and the number of bodies and agencies that surround it does perhaps need to be rationalised. But that must not be at the expense of the important principle, which Charlton has taught us again, that policing demands accountability. As he put it on page 292, a police force is an aspect of the entitlement of a sovereign nation to control its citizens to the rule of law. It exercises primary law enforcement. It is entitled to use force and may be armed. Where respect for the truth fades within such an organisation, where structures of command and accountability break down, and where the police do not offer a complete day of work in exchange for being remunerated by the taxpayer, an essential component of a modern country ceases to function properly. Police action may become fitful, inefficient, or even dishonest. This helps no one. This tribunal, again I'm quoting from page 292, this tribunal has been about calling that police force to account. The Morris Tribunal was about the same thing. The Commission of Investigation conducted by Mr Justice Kevin O'Higgins, which reported to the Minister for Justice and Equality on the 25th of April 2016, was about the same thing. Central to these inquiries has been the truth. This is not the time to consider abolishing any body whose function is to demand openness, accountability and the truth. In that context, we ask why, most notably, the authority's role in appointment to senior officers and ranks has been diluted, as has its role in standard setting for the provision of policing services and oversight of strategic planning and corporate governance arrangements. It is important to remember that two members of the Commission on the Future of Policing, Dr Vicky Conway and Dr Eddie Malloy, opposed recommendations to set up a new Garda board. They said, against a background of decades of apathy, of antipathy in Ireland towards external oversight and accountability for policing, we believe the inclusion of this board as an additional element in the oversight and governance architecture and the consequential dilution of the role of the external oversight body, until now the policing authority, does not offer the best prospects of achieving the goal of unambiguous, independent, empowered, transparent accountability. While exchanges between the policing authority and the Garda Síochána may have appeared fractious, it is still early days in the development of an effective system of governance. Our proposal would be simply to build on the progress made to date by the policing authority, within which our view has been both supportive and necessarily challenging in its engagement with the Garda Síochána. We believe that the solution should be to adequately empower the policing authority while encouraging a maturation of the culture of the Garda Síochána concerning external accountability." End quote. That minority voice is an important one. It stresses external oversight and accountability as core features, more importantly than avoiding fractious exchanges. And it stresses also that Garda culture concerning external accountability must mature. But the minority voice has not been heard by this government. At present, it is the policing authority that oversees the provision of policing services. It approves the 3-year strategy statement and the annual policing plan. It sets annual policing priorities and performance targets, and it has responsibilities and functions concerning selection, appointment, suspension and removal at senior levels. What exactly does the Minister say is not working or not working well in these arrangements? We know that the policing authority opposed losing these functions. It said that, and I quote, the impression apparently held and conveyed by the Commission on the Future of Policing that the existence and functioning of the authority under provisions of the 2015 Act served to limit the capacity of the Commissioner to direct and manage the Garda Síochána was unfounded and not supported by any clear evidence. What is the Minister's view of this clear difference of opinion? And what is his evidence? And incidentally, what possible basis in law is there for the assertion in the exploratory memorandum that establishing a Garda board will, and I quote, facilitate the Minister's department in pulling back from the involvement in day-to-day management of Garda Síochána? The department has no mandate whatsoever to be involved in day-to-day management. If this change is being made simply to stop the department from doing what it should not be doing in the first place, that's a poor reason for change. Finally, apart from the structural issues, a bill this size throws up a host of smaller questions that will need to be teased out. Now, I mentioned just two as examples. First, under Section 3, one of the security service functions of the Gardaí will be to identify foreign capabilities, intentions or activities within or relating to the state that have an impact on international well-being or economic well-being of the state. Now, safeguarding the economic well-being of the United Kingdom is a function of the British security services, on foot of which surveillance, for example, GCHQ takes place. Competing bids from different countries to attract major FDI projects are monitored in that country, in the interest of international development policy. Does anyone seriously suggest that the Gardaí do the same here, or that they should? Why is this enabling function in the bill? Secondly, Section 32 appears to vest in a judge conducting an inquiry into a Garda Commissioner or Deputy Commissioner the same powers as the High Court to enforce the attendance of witnesses and compel the production of records. This seems, on the face of it, to be unconstitutional. The enforcement powers of the High Court boil down to the power to committee a person for contempt of court if they did not comply. But it is not possible to confer that power on a person acting outside of the court system. These and other issues will be dealt with in committee stage, but at this stage, we need to hear a convincing outline as to why the policing authority is the chief target of this bill and why we should believe that the new arrangements will be better.